So as discussed in the previous video about the demergers, now let's look into these sections along with the rules. So the power of tribunal to enforce compromise or arrangement, procedure in respect of approval scheme of demerger. So rule 3 says application for the order of meeting. The company can go ahead, request the tribunal for the order of meeting, and then application has to be filed in NCLT 1 accordance with the National Company Law Tribunal Rules 2016. A notice of admission in NCLT 2 and a affidavit in NCLT 6 and a copy of scheme of compromise or arrangement as per 230 subsection 2 with the fee. So these are the documents required to be made, where for more than one company a joint application shall be sufficient. So if there are more than one company which is required to be demerged, then they can look forward for a joint application. And where the company is not an applicant, then a copy of notice of admission here, NCLT 2. So let's just to have a grip on the forms, let's just start practicing now. The NCLT 2 affidavit NCLT 6 shall be served on the company for the purpose of demerger, or if the company being wound up shall be served on liquidator. So if the company is not an applicant, so it can be served by to the company. If the company is being wound up, then shall be given to the liquidator. Talking about further, if you see this, we connect. The application is required to be made 14 days prior for hearing of notice of admission. Okay. Next is disclosure in application made to the tribunal for compromise or arrangement. So that has to be given a creditor responsibility statement in form CAA1 and shall be included in corporate debt restructuring. Next we have is direction at hearing of application. So for this I will drag you to the module. Just give me a second. Okay, here we go. Alright. Unfortunately don't have it. Just a second. Now talking about the direction at hearing of the application, so point A to I are as here. So they have to determine the class and class of creditors whose meeting or meeting have to be held for considering the proposed compromise or arrangement, or dispensing with the meeting for any class of creditors under subsection 230 under subsection 9 of section 230. Fixing the time and place, appointing the chairperson for the meeting or the meetings to be held as the case may be. Fixing the term of the appointment including the remuneration. Fixing the quorum and procedure to be followed at the meeting or the meetings, including the voting in the person or by proxy or by postal ballot through electronic means. Determining the values of the creditors or the members of the creditors or the member of any class whose meeting have to be held. Notice to be given in the meetings and advertisement of such notice. Notice to be given to the sectoral regulators. Time within the chairperson is required to report to the tribunal about the meeting being concluded, and such as the matters tribunal may deem necessary. So अगर मैं just में बात करूँ, so पहले आपको ये tribunal will give the direction कौन से class या classes of creditors की meeting होगी. दूसरा time and place where the meetings were supposed to be executed. Chairperson appoint करेंगी and उसका appointment के बाद terms of his appointment and talking about the remuneration. Quorum for that meeting including the voting by proxy or by postal ballot or voting by electronic means. Now talking about जहाँ पे बात आती है voting by electronic postal ballot as per the company's amendment, if there is voting by postal ballot, so ये voting facility section 108 के साथ भी आपको comply करना पड़ेगा. Now, determining the values of the creditors or the members whose meeting have to be held. Notice to be given to the meeting and the advertisement such notice. Sectoral regulators को time within which the chairperson shall report and such other matters. Let's go back to the chart. Talking about the notice of the meeting. Notice of the meeting. Direction for the meeting is to be given by the NCLT. Notice shall be given in accordance with 230 subsection 3 in form CAA 2. So for the purpose of notice CAA 2. Talking about these forms have been already discussed in prior videos, so you can look into it, as well as these sections, and shall be sent individually to creditors and the members according to the direction given by tribunal at least 1 month before. Moving further, along with the copy of scheme, so that shall be accompanied with scheme, and the scheme shall have the following details: details of the orders of the tribunal, details of the company, compromise and relates to more than one company, facts and relationship subsisting between such company, date of the board meeting, approval for the purpose of scheme of compromise or arrangement, direct present and voted in favor of scheme of arrangement. 2. So I have to mention who all were in favor. Disclosure on effect of compromise and arrangement. Disclosure about the effect of compromise arrangement on material interest of director, KMP, debenture trustee. Explanatory statement. Investigation or proceeding against the company. Available of document and inspection. Then they have to have the NOC that be from the sectoral regulator, that they don't have any issue. Going further with rule 7, advertisement of the notice in form CA2. So same form will be advertisement. So one shall be in English and one in newspaper in the state where register office is situated, or any such newspaper tribunal may direct. 230 subsection 3 says it has to be also on the website of the company. Next we have is, in case of the listed company, also on the website of SEBI and on the recognized stock exchange at least 30 days prior from the date of meeting, provided where separate meetings are to be conducted, joint advertisement can also be given. So ऐसा नहीं है कि if there are 2 or 3 meeting has to be conducted, so you have to give 2 or 3 different advertisement. You can give a joint one as well. Rule 8, notice to statutory authorities, very important, shall be given in CAA 3 along with the copy of scheme, explanatory statement, disclosure mentioned in rule 6, which has been have. Now send the notice without delay to the members and the creditor by speed or register post. Now it shall be the notice which is required to be sent to the CG, ROC, Income Tax Authority, RBI, SEBI, Competition Commission, Stock Exchange, other securities regulators. And with respect to the above, which I have discussed, the sending the notice without delay to after the notice sent to the members and the creditors, any sort of representation, if received within the period of 30 days, irrespective of the fact if from the members of the creditors or the regulatories, shall be sent to the tribunal within 30 days. After that, and such shall also be sent to the company. If no representation, then the authorities have no representation. I'll go on with the proposed scheme. Talking about the rule 9, voting by in person or by proxy, postal ballot or e-voting for adoption of scheme. So any process for the voting can be adopted. Where about the proxies, shall be in prescribed form, duly signed by the person entitled to vote, and submitted not later than 48 hours. So 48 hours wala to expect, we are aware of. Body corporate being a member or creditor can authorize the person to act as a representative. Copy of the resolution of board of directors and other government body certified by the director, manager, secretary, or other authority officer. No minor shall be proxy. Minor who does not know, and if there any special who does not know English, witness there was to certify that terms and conditions were explained before he was appointing one. Now, the proxy is blind, incapable of writing, may be accepted such member or creditor the signature of his witness to add along with that description and his address, that who has explained such person about the fact that being some so or so person is appointing at the proxy. Rule 11, copy of compromise or arrangement to be furnished by the company entitled to attend meeting. Any member, creditor, a copy of scheme shall be served within 1 day of request. So being a member, requested to the company 1 day. Scheme shall be delivered. Affidavit of service, chairperson for the meeting or any other person directed to issue the advertisement of notice to file an affidavit before tribunal not less than 7 days before date fixed of the meeting. So 30 days from the notice and 7 days prior after give notice to the tribunal for the first meeting or for the first meeting, confirming with the directions for advertisement as duly complied. Okay, should be done by the chairperson or any other person authorized in this behalf. In the case of default, application along with the copy of the last order issue shall be postponed, shall be posted before tribunal for making such order as may deem fit. If it's not done, then tribunal को intimate करना and they can look into what exactly requires to be done. Result to be decided by the voting as per Rule 5. Report shall be in CAA 4. To state the number of creditors or the class of creditor, number of member or class of member who were present and voting in person or by proxy and were applicable who voted through the electronic means, and where applicable who voted through the electronic means, their individual values and the way they voted. Rule 14, report the result of the meeting by the chairperson fixed by the tribunal. If no date, then within 3 days from the conclusion of meeting. So from the meeting within 3 days, report to tribunal by chairman. Next we have is Rule 15. 3 days or any other time as may be specified. So Rule 15, petition for confirming compromise or arrangement from the date of submission of CA 4 within 7 days after appointment of scheme without modification. Okay, or a petition has been confirmed or not from the submission of CA 4. So CA 4 यहाँ से submit होगा, यहाँ से 7 दिन के अंदर so for the purpose of confirmation that scheme has been approved or not with or without modification. File the petition to the tribunal. अब ये 7 दिन के अंदर CAA 5 जाएगा. ये CAA 4 क्या था? Where the scheme is proposed for the purpose of recommendation of the any company or the companies or amalgamation petitions shall play appropriate direction under 232 of the Act. If the company fails to file the petition, the member creditors with the leave of tribunal. If it's not done, then you have to take the approval from the tribunal and can the petition at such later date and will be liable for the cost thereof. Rule 16, date and notice of hearing to be filed fixed by the tribunal. So from the date of hearing, if I talk about over here, yep, notice of admission it was, and there is also a date of notice of hearing. So that was for admission and this is for hearing. So notice to be advertisement in the same newspaper जहाँ पे last time आपने a notice circulate करा था, या the tribunal as may specify 10 days prior from the hearing. Notice to be served by the tribunal. Objection their representatives. Objections or to their representation under 230 subsection 4. CG and other authorities who have made representation as per Rule 8. Rule 17. Order on petition by tribunal may be with or without modification as tribunal may deem fit for the purpose of compromise or arrangement. Okay, so once the notice has been given, then you look forward to what tribunal will look into the any objections or anything sort which has been received, and then tribunal may think with or without modification can sanction the scheme. File the copy of order once approved with ROC from the date of receipt of order, such time as may be fixed by tribunal. An order shall be in form of CAA 6 with such variation as may be. Rule 18. Application for direction under 232 of the Act, where scheme has been proposed for the purpose of in connection with the scheme for reconstruction or amalgamation of companies as a matter involved cannot be dealt adequately. Application shall be made to the tribunal to the proceed to be taken. So if it's not able to be in accordance with 232, then tribunal को आप intimate करोगे and he'll look into the matters which has to be taken care of. Notice of admission in such cases shall be given in such a manner to such person as tribunal may direct. 19. Directions at hearing the application. Tribunal may give such directions. It may deem fit. Inquiry as to the creditor, transfer company, and securing any claims of the dissenting shareholders. Creditor may think just fit and appropriate. So this is for the dissenting shareholders. Rule 20. Order under Rule 230 of the Act. Read with 230 of CAA 7 with such variation. So after that there will be any further variation which is required, that will be given in CAA 7. Statement of compliance for merger amalgamation under the scheme is implemented with ROC within 210 days or the end of each financial year has to be submitted in CAA 8. So statement of compliance देना है ROC को 210 दिन के अंदर from the end of each financial year in CAA 8. Taking further, report on working either on its own motion or application of any interested person direct the company where the company is being wound up its liquidator. So you can give the ask for the report for the same. Rule 23. Liberty to apply for any question of the tribunal for merger, compromise, liquidation, or for working of compromise and arrangement scheme and its working. Application give to the tribunal for directions as to the notice of advertisement to be issued. Tribunal may on application may pass direction or modification as required for the working of scheme. Liberty of tribunal. If they require, ask for the information along with the affidavit. Tribunal to give direction other than those what is specifically mentioned in the Act. Merger and amalgamation of certain companies. Now this is important, look into it. 233 1 subsection 1 clause A to invite objection or suggestion for ROC, official liquidator, or any person affected shall be in form CAA 9. 233 subsection 1 clause C. Declaration of solvency to be submitted by the companies in CAA 10 before the meeting of creditor approval of the scheme. So creditor scheme approval से पहले आपको ये चीज़ mention करनी है. Scheme falling within the provision of 233, if the requirement are not met, the company may opt for what say under undertake such scheme under section 233 to 232. So if it's the requirement are not met, 233 can email it, then you have to go through the 232 to 32. So that's a lengthy procedure, but there is a crisp one. 233 subsection 1 clause B and D. Notice of the meeting accompanied by the statement. 233 subsection 3 read with sub rule 3 and sub rule 6 discussed already. Declaration of solvency has to be given, a copy of scheme, and 233 subsection 2. So transferee company shall within 7 days from the conclusion of meeting of the members of the class of creditor along with the report of each meeting in CAFO has to be filed with CG ROC in GLN 1 an official liquidator via hand delivery or by register post or speed post. Moreover, the no objection or suggestion is received from ROC or OL, or where such objection are not received and CG of opinion that such is in public interest, CG to issue confirmation order in CA 12. So यहाँ पे this is going through a quick procedure. So CG will give the orders that go ahead and do it. CG order ये आपको ROC के पास 30 दिन के अंदर अंदर देना है. INC objection to be received to CG consider such in public interest, not file an application before tribunal in 60 days requesting to consider the scheme in CAA 13. Objections अगर आएंगे we'll consider that is in public interest or not. We have to require to file the application before the tribunal in 60 days from requesting the consider of scheme. 26 notice to the dissenting shareholders. Section 235 at the last known address of the transfer company by the transferee company. The notice shall be given. Declaration of price of purchase for the minority shareholding has to be done by register valuer. Section 247. Price to be paid by acquirer shall be reflected in 236 subsection 1 for the purchase of equity share of minority company with the following rules. If the company is listed, then the rules and regulation register value to provide the valuation report on the basis of valuation report board, and they look into the valuation price and shall be given accordingly. Unlisted or private company, highest price paid by the acquirer in previous 12 months, or fair price determined by the registration value after taking the net worth and the book value of shares, earning per shares, or in such other parameters, providing the valuation report to the board of directors along with the basis of valuation. 28. Circular with respect to the scheme of merger amalgamation. 238 subsection 1 clause A. Every circular containing offer the scheme of contract involving transfer of shares or any class and recommendation to the member of the transfer company by its director to accept such offer be accompanied by the particular in CA 5 present the circular to ROC for registration. Rule 29. Appeal. Any person aggrieved by the order 238 subsection 2 and refusing to register circular may file appeal in NCLT 9 and NCLT 6. That will be your appeal in along with the affidavit. So this was 29 rules with respect to the demerger. And the next you have coming up with tax aspects of demerger.